let's get
Allen versus Allen et al. Case number 22002-277 PD.
All right, Mr. Bowman, your appearance, please, sir.
May it please the court, Your Honor, Victor Bowman, P33764, appearing for the defendants, Leroy Harper and Viola Allen.
Okay, you must be new on the case. I didn't see an appearance or.
It was filed yesterday.
Okay, it might just be making its way through, but yeah. Mr. Allen, Anthony, good morning as well. I see you.
Good morning, Your Honor.
Is there any of the other Allens here or just you on behalf of the client, Mr. Bowman?
It might be on.
Tanya Allen.
Oh, Tanya Allen. Okay. Is Tanya Allen on the defense side or the plaintiff side? I can't remember.
Defense side.
Defense side.
Defense side. All right. Mr. Bowman, you represent Tanya, right?
No, I represent Leroy Harper and Viola Allen.
And Viola. And okay. All right. So what's up today? Motion, relief of judgment. I don't even have that motion here in the Register of Actions. Rod, do you have it?
I'll have to open it up and see here, Judge. Let's see.
Your Honor, if I may, it's been kind of confusing.
That's the understatement of the year.
Yeah, and what I thought was up for today was some type of motion for reconsideration, and that means if there was a motion for reconsideration, apparently the plaintiff must have filed some type of motion for something. You denied it, and if it's a motion for reconsideration, then the improper plaintiff has not filed he is not done with the appropriate procedures for filing a motion for reconsideration.
Hold on. Let me hear.
Let me see. I got a press appeal, and I'm trying to see what this is.
And then
the only thing I got, some filed on 8/12 as a miscellaneous motion, says notice regarding service and request for clarification, but that's the only so-called motion I have.
Your Honor, let's
hear Anthony. Go ahead, Mr. Allen.
It was filed, I believe, on August the 5th.
August the 5th.
And Patillo had withdrew the next day on August the 6th, the former counsel.
Okay, I'm pulling up August 5th. Motion for relief from judgment for fraud upon the court.
Yes, that would be it.
Okay. Mr. Bowman, are you prepared to respond to that today?
What's the motion today, supposedly?
Yeah.
I have Mr. Harper, who was present next to me, and it is my understanding that the court denied Mr. Allen's motion because it, quote unquote, didn't make any sense, and you denied his motion.
Yeah, that weren't we here last? I mean, we were here last time, and I do remember saying that. And as I look at the motion here, I conclude
Your Honor,
again.
we never had the motion to be even heard. The motion was precipied after Patillo withdrew. And then we have the court date for today, this morning.
All right, make your record, Mr. Allen. I'll entertain it. It still doesn't make any sense, but what you got in writing here, but you want to clarify it, go ahead.
Okay, so you want me to go ahead and make my oral argument?
If you could, briefly, sir.
Okay, so the motion that I filed is not about ordinarily newly discovered evidence. It is about fraud upon the court, which strikes at the very integrity of the judicial process. In the recent summary judgment, the defendant testified and argued that my father was the owner of the jewelry store and that I was not. The false statement was material, and it was the very basis for the judgment against me. But we now have sworn testimony from 30.
Go ahead, Anthony. Go ahead.
But we now have sworn testimony from 30 years ago from this same defendant under oath, where she stated clearly that I was the owner and that my father had no business rights or interest in that store. At that time, the detectives, the attorney, and the courts itself all confirmed that I was the owner. The record could not be clearer. We also had a robbery 2 months prior to that open murder case And the police also returned the same items that were stolen to me and put my name as the owner. The contradiction is undeniable, but the defendant told the truth 30 years ago, but lied in this courtroom to win a judgment. That is not a mistake, and it is not a discovery issue. It is fraud upon the court. So, Your Honor, fraud upon the court cannot be excused by arguments of finality or deadlines. The law is clear. A judgment obtained by fraud has no legitimacy. The court itself was misled, and justice requires that such a judgment cannot stand. For these reasons, I respectfully ask that the judgment be vacated and the matter reopened, because allowing the judgment based on deliberate false testimony would undermine the integrity of this court. Thank you, Your Honor.
Thank you, Mr. Allen. Mr. Bowman, do you care to respond, sir?
Yes, Your Honor, I'm kind of hearing this for the first time like you are, but it appears what this gentleman is talking about is about some proceeding which happened in a criminal case decades ago. So if that's what we're talking about, this lawsuit against Mr. Harper or Ms. Allen, A, is of no jurisdiction, B, is way late, and C, still doesn't make any sense. And lastly, if he's talking about fraud, I haven't seen any document, because if he's dealing with about fraud, then he's got to file some type of motion which specifically states the fraud. And so he's late, it doesn't make sense, and it is improper. And I request that his motions be dismissed with prejudice.
Mr. Allen, anything you care to add, sir, in reply?
Yes, Your Honor. The defendant, Viola Allen, had said in court multiple times that my father was the owner of the business. They brought up the case 30 years ago about my father, and they never looked into the case to see that this evidence is there. Certified court documents 30 years ago from the Sixth Circuit Court and Southfield Court that shows that I am the owner. And these statements was done under oath in court 30 years ago. So these are archived records during the time that this business was actually open. So the evidence is sitting there. I didn't see it. The opposing counsel, not this one, the one prior, spoke of this incident 30 years ago and never investigated this to see that that was fraud upon the court, that she clearly said, I am not the owner, when it is with undoubted that I am the owner. That was done 30 years ago during the time when this business was actually in business. So the evidence to look and see who is the owner would have been very clear and undisputed.
Right. Well, the court's had an opportunity to review the motion. The court appreciates the brief oral argument crystallizing the issue, and the court isn't convinced that that the motion that there are grown. What are you laughing at, Mr. Bowman?
Oh, because it froze right at the good part. That's why I laughed.
Okay.
Your video froze. I'm sorry.
My video froze?
Yes, your video froze.
Rod,
Just for a couple of seconds. You good. Go ahead.
All right. Okay. Yeah, the court isn't convinced that relief under 2.612 is warranted based upon the presentation and lack of exhibits, and the court will otherwise deny the motion for relief from judgment based upon the fraud and something that happened 30 years ago.
And this is this is with prejudice, Your Honor.
The motion's granted, or the motion's the motion for relief is denied. Period. End of story.
But Your Honor, can I state something? When you say that exhibits and the exhibits are the court documents that were certified that came directly from the courts themselves 30 years ago, which is relevant to the case because this is when the jewelry store was actually open and up and running.
Right. Okay. Well, with
and that was clear. I was not convicted of anything. I was acquitted of all charges. And it was stated clearly that I am the owner, not only from the defendant who said that I wasn't, but the defendant 30 years ago said I was. And I submitted all of those exhibits in the documents to show clearly what she said.
Well, thank you for that clarification. The court isn't
Okay.
convinced that relief is warranted. This is something that needs appellate review, both the underlying decision as well as this decision. And you folks have to move forward in that regard. Otherwise, the court is not reopening the matter at this point.
Okay.
Thank you all.
Okay.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. Welcome, gentlemen.